There has been a lot of legislative activity on harassment issues since the Me Too era began in late 2017. Been tracking that pretty carefully, and it's going to be an area like drug testing, like non-competes, certainly others, that employers who are not only in different states, but even in different cities in the same state sometimes, are just going to need to be aware of the differences. You may not necessarily be able to have a policy or a practice that is exactly the same across the whole company, and that's going to make your life somewhat harder. As I say, we've been tracking these fairly carefully. Just by way of example, just mention a few states. In Minnesota, there's a bill that would legislatively change the severe and pervasive standard for what is sexual harassment. That's an interesting one. In Maryland, legislation was signed requiring certain reporting by corporations of harassment incidents. I see legislation in Illinois, in California, that might change the number of employees that causes an employer to be subject to state laws on discrimination or harassment issues. New York State has legislation there about extending Title VII harassment protections to independent contractors, not just employees. California, as is often the case, has a lot going on requiring employers to maintain sexual harassment complaints in their files for 10 years. Those are just some examples. A couple municipalities. Chicago has an ordinance relating specifically to hotel employees, being able to have a panic button to allow notification promptly if they're in a harassment or worse kind of situation with a guest. New York City has its own poster. So the point of all this is not to review those comprehensively, teach you about them in this video. If you have questions about anything I said in particular, let me know. The point is to, again, just focus on this point that labor and employment law is becoming much more localized, much relatively less federal activity, more state activity, more local activity, and therefore more differences. Some of these, this is not necessarily reason to panic. Some of these are just good practices. Some of them a lot of employers are doing anyway. So this is something you can work through, just as you do the drug testing, the non-competes, the other areas that tend to be very state specific. But we just need to be very aware of it.